Almighty God, who, in thy infinite wisdom and providential goodness, has appointed the offices of rulers and councils for the welfare of society and the just government of man. We beseech thee to behold with thy abundant favor us thy servants, whom thou hast been pleased to call to the performance of such important trusts in the Commonwealth of Dominica. Let thy blessing descend upon us here in this Parliament assembled, and grant that we may, as in thy presence, treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to promote thy honor and glory, and to advance the good of those whose interests thou hast committed to our charge. All which we ask in the name and for the sake of our Lord and Savior Jesus Christ. Amen. Good morning. House resumes, and I must first apologize to my slight tardiness. Members should know that is very unusual for me, and I can't even say I have an excuse other than that I slept a little too much. It happens. And so the debate has ended, and so we move to the next stage of the proceedings as they relate to supplementary estimates motions. The debate, as I said, has been concluded, and so the supplementary estimate shall now be referred to the Committee of Supply of the whole House, and the cameras and radio will give us our chance. House resumes, And I have to report that the supplementary estimates have passed through the Committee of Supply without amendment. The question is that the supplementary estimates for $14,379,814.16 be approved. Those in favor? Those against? The ayes have it. And the bill now, okay, yes. No, let me tell you. The Prime Minister has to say something, no? Because well, the bill. Be it resolved. Where is it?
Madam Speaker, I move that the bill shortly entitled Supplementary Appropriation 2014-2015 Act 2015 be read the first time.
I beg to second, Madam Speaker.
Supplementary Appropriation 2014-2015 Act 2015.
The bill has been read a first time.
I move the second reading of the bill shortly entitled Supplementary Appropriation 2014-2015, Act 2015.
I beg to second that, Madam Speaker.
She has to just read it.
Madam Speaker, I commend the Supplementary Appropriation Bill to the House.
Beg to second, Madam Speaker.
It has been moved and seconded that the bill shortly entitled the Supplementary Appropriations Act of 2015 be read a second time. Those in favor? Those against? The ayes have it.
Supplementary Appropriation 2014-2015, Act 2015.
Madam Speaker, I move that the bill shortly entitled Supplementary Appropriation 2014-2015, Act 2015 be read a third time and passed.
Beg to second, Madam Speaker.
It has been moved and seconded that the bill shortly entitled the Supplementary Appropriations Act of 2015 be read a third time and passed. Those in favor? Aye. Those against? The ayes have it. The bill will now be read a third time.
Supplementary Appropriation 2014-2015, Act 2015.
The bill has been read a third time and passed accordingly.
Second and third reading of bills.
Madam Speaker, I move that the second reading of the bill shortly entitled Banking Act 2015.
Beg to second, Madam Speaker.
Madam Speaker, before I read the opening statement on the Banking Act, I just want to inform this Honorable House that effective today, the 20th of May 2015, Dominicans will no longer require visas to go into the Schengen states. Madam Speaker, you're speaking about the following countries: Austria, Estonia, Greece, Latvia, Netherlands, Slovakia, Belgium, Finland, Hungary, Lithuania, Norway, Slovenia, the Czech Republic, France, Iceland, Luxembourg, Poland, Spain, Denmark, Germany, Italy, Malta, Portugal, Sweden, and Switzerland. In addition to that, Madam Speaker, effective May 15, 2015, holders of Dominican passports are not required to acquire a visa to travel to Brazil. So that's another country, Madam Speaker. Just to say, Madam Speaker, that we had to go through a very rigorous process of acquiring the visa-free entry into the Schengen states. They had to examine the securities of our passport system, our border control system. They also asked extensive questions and reviewed our due diligence process in respect to our economic citizenship program. Several questions were asked. They came to do their independent assessment, and based on those, their own independent reviews and assessment, that they have taken the decision to extend that privilege to Dominicans effective today, not requiring visas to go into the Schengen states. I want to place on public record, Madam Speaker, if you allow me just 1 second, to say a special thanks to the French Republic and the President of the French Republic, because France itself was very instrumental in advancing Dominica's case at the European Council, Madam Speaker. Thank you for the indulgence, Madam Speaker. Madam Speaker, the global economic challenges which began in 2008 was to a large extent the result of weakness in the financial sector. We would have followed the news on the international press as they tried to explain and even justify the actions that caused the fallout. It was quickly recognized that whatever the causes, the action to resolve the weakness needed to be addressed swiftly and thoroughly. Madam Speaker, the Caribbean was not spared the effects of the global crisis. Our economies took a hit and our financial sector was negatively impacted. We need not be reminded of the CLICO-BICO debacle. But I am pleased to say, Madam Speaker, that at the level of the Monetary Council of the Eastern Caribbean Currency Union, the ECCU, and with the commitment of individual member governments, we were able to bring some relief to BICO policy holders. Regrettably, we are still in discussion on CLICO. We have since passed new legislation which has enhanced the supervisory and regulatory framework for the insurance sector, and we expect that this will give better protection to policyholders. There were also challenges within the banking subsector. We would be aware that the Eastern Caribbean Central Bank intervened in 3 banks in the ECCU and had to give support to a 4th. The events within that subsector brought to the fore the need to further strengthen the regulatory framework. Madam Speaker, this is the intent of the banking bill which is brought to the Parliament today. It is to enhance the banking sector supervision so that depositors can be protected. There are some fundamental differences between this bill and the 2005 Act. The main difference is that the authority for licensing, regulation, and supervision is now directly the remit of the central bank. This is to ensure that there is no ambiguity in the actions that need to be taken in respect to banking operations. For example, in the 2005 Act, the granting and revocation of a license was done by the Minister for Finance on the advice of the central bank. Another significant difference is the introduction of corporate governance measures, which will ensure that boards of directors, shareholders, and staff are more accountable for the actions in the operations of banks. Madam Speaker, this is an extensive and detailed bill, but at this point, I will attempt to summarize some of the key provisions. This act is cited as the Banking Act 2015. The act is expected to come into effect by an order made by the Minister and published in the Gazette. Section 2 of the bill contains the definitions of all the key terms. Part 2 deals with licenses and includes Section 3 to 19. A license to carry out banking business will be issued by the central bank. This is one of the changes being made from the previous arrangement, where the Minister for Finance issued the license on the recommendation of the central bank. A person shall not carry on banking business in the currency union without a license granted by the central bank. Section 3 of Part 2 provides all the requirements for the granting of a license and the penalties associated with contravention of these requirements. Section 4 provides authority to the central bank, accompanied by a police officer, to enter and search the premises of a bank operating without a license. At that time, the central bank can seize relevant documents and cash found on the premises to ascertain whether the person is carrying on banking business without a license. In Section 5, the central bank may appoint a receiver for failure to hold a license. In Section 6, a person holding funds which was obtained by doing banking business without being in possession of a license is expected to repay such funds as directed by the central bank. An application for a license shall be made in writing to the central bank and shall be accompanied by the non-refundable application fee and the requisite documentation. Included in the list of documents are the following: authenticated copies of the instrument under which the applicant is organized, a statement of the address of its head office and the locations of the principal and other places of business where the applicant proposes to do business, detailed information regarding the persons who will hold or ultimately benefit from significant shareholdings, directly or indirectly, the respective values of the shares, and the percentage of ownership. Detailed information regarding the directors and officers, including their qualifications and experience, financial position, business interests, and performance of the business concern under their control or management. Documentary evidence of the capital of the applicant seeking to be licensed, including the original sources and any other sources of funds. A business plan, including projected statement of financial position, financial performance, and capital, and full particulars of the business the applicant proposes to operate. An operating plan and documented internal controls system. Section 8, Madam Speaker, includes the conditions under which the central bank may grant or deny a license. According to Section 9, every licensed financial institution and licensed financial holding company shall pay an annual license fee. All license fees paid under this Act are payable to the central bank not later than the 31st day of January in each year, or such later date as may be specified by the central bank. The activities that may be undertaken by a licensed financial institution are provided in Section 10 and include acceptance of deposits and other repayable funds, lending, financial leasing, investment in financial securities, money transmission services, issuing and administering means of payment including credit cards and traveler's checks, drafts and electronic money, guarantees and commitments, the keeping and administration of securities, credit reference services, safe custody of valuables, electronic banking, payment and collection services, dealing in foreign currency, Madam Speaker. According to Section 11, a license issued under this Act is subject to the conditions that a central bank may impose, including the activities in which the licensed financial institution is permitted to engage. According to Section 14, the central bank may revoke any license to carry on banking business in the currency union if the licensed financial institution fails to commence operations within a period of 12 months following the granting of the license. In connection with the application for the license, provided false, misleading, or inaccurate information or suppressed material information, fails to comply with the conditions of its license or the measures required by the central bank in accordance with Section 11, is in breach of any of the provisions of this Act, which is applicable, ceases to carry on banking business in the currency union, is conducting its affairs in a manner detrimental to the national and regional interests or to the interests of its depositors, fails to maintain sufficient capital or liquidity to meet its liabilities, has not fulfilled or is unlikely to fulfill the minimum criteria for licensing under this Act, merges or amalgamates with another company or licensed financial institution, and the license is no longer required, or or the parent company of the licensed financial institution loses its authorization to conduct banking business or business of a financial nature in its home jurisdiction, or bankruptcy or insolvency proceedings have been or are to be initiated. Part 3 of the bill addresses ownership structures within the banking sector and includes sections 20 to 34. Except with the written approval of the central bank, no person acting directly or indirectly, alone or together, with one or more persons, shall hold or acquire shares in a local licensed financial institution which, together with any existing direct or indirect holdings of that person, would exceed the supervisory thresholds of 10, 20, or 50% of the share capital. In the case of a local licensed financial institution not having a share capital more than the supervisory thresholds of 10, 20, or 50% of the total voting rights of all the members entitled to vote at a general meeting of the local licensed financial institution. The central bank will be required to grant approval for any other structure than that prescribed above. In accordance with Section 26, except with prior notice to the central bank, no person shall sell or dispose of shares in a licensed financial institution to any other person if, as a result of the transaction, their shareholding falls below the supervisory threshold of 10, 20, or 50% of the share capital. Further, in Section 27, where the central bank determines that the interests of a group or two or more shareholders of a licensed financial institutions are connected, the total holdings of those shareholders shall be combined and deemed to be the holdings of a single member. Madam Speaker, in accordance with Section 32, Part 3, does not apply to the government or any other person who, at the commencement of this Act, has acquired more than 20% of the total voting rights of all the members of the local licensed financial institution. But no person shall, without the consent of the central bank, acquire any additional shares which shall have the effect of increasing that person's percentage of the voting rights. Madam Speaker, Part 4 of the bill addresses matters related to financial holding companies and includes Section 35 to 43. Section 35 provides the requirements for licensing financial holding companies, while Section 36 deals with the application process. In considering a request to grant a license to a financial holding company, the central bank shall take into account the information on whether the person or persons controlling the proposed financial holding company are fit and proper, or maybe persons likely to prejudice the interests of depositors and other customers of the licensed financial institution in question. In Section 38, the conditions under which a license will not be granted by the central bank are stated. Among other things, the central bank shall not grant a license under this section unless it is satisfied that the feasibility report is based on sound analysis. Additionally, the proposed officers should be fit and proper, meaning that their integrity is established and their qualifications and experience are appropriate for their respective positions, taking into account the company's business plan. A license granted under this section is not transferable or assignable. The central bank may set conditions to the license of a financial holding company under this section, including conditions to ensure that the capital available to the financial group is adequate and will not jeopardize the financial position of the licensed financial institutions within the financial group. There will be restrictions on the activities that a licensed financial holding company shall undertake, and failure to comply with the requirements of this Act will result in the revocation of the license. Part 5 of the bill addresses the financial requirements and limitations of banks and includes sections 44 to 58. Every licensed financial institution shall maintain in Dominica, unimpaired, paid up, or as the case may be, assigned capital at least equal to the minimum amounts specified in accordance with the following requirements. If operating as a bank, the minimum required capital shall not be less than $20 million. If operating as a credit or other financial institution, the minimum required capital shall not be less than $5 million. Every licensed financial holding company shall maintain in Dominica unimpaired, paid up capital at least equal to 3 times the minimum amount applied to the licensed financial institution for which it is the holding company, or such other amount as the central bank determine. Every licensed financial institution shall maintain a reserve fund, and shall, out of its net profits of each year, transfer to that fund a sum equal to not less than 20% of profits whenever the amount of the reserve fund is less than 100% of the paid up, or, as the case may be, assigned capital of the licensed financial institution. At the same time, no licensed financial institution or licensed financial holding company shall declare, credit, or pay any dividend or make any other transfer from profits whenever the declaration, credit, payment, or transfer will result in an impairment of the capital, or if the licensed financial institution or licensed financial holding company realizes a net loss for that financial year. Where necessary, the central bank may require a licensed financial institution or a licensed financial holding company to maintain additional capital as it may consider appropriate to address risk in the licensed financial institution, the licensed financial holding company, or in the financial system. The central bank shall also issue liquidity requirements that require licensed financial institutions and licensed financial holding companies to hold adequate and appropriate forms of liquidity, and the licensed financial institution and licensed financial holding company shall comply at all times with the liquidity requirements issued by the central bank. The central bank may determine that a licensed financial institution shall not directly or indirectly incur exposures in a manner that the total value of the exposures is at any time more than 25% of the aggregate amount of the licensed financial institution's capital base, unless prior approval is obtained from the central bank. Further, a licensed financial institution cannot permit exposure to any of its related parties unless an exposure is granted on non-preferential terms. All loans to employees shall be subject to the general credit policies of the licensed financial institution. Lending on preferential terms to employees of a licensed financial institution shall only be permitted where, 1, it forms part of a written employment package or employee benefits plan approved by the board, or 2, it is consistent with a written board policy for employee lending that is in compliance with prudential standards issued by the central bank. A licensed financial institution shall not engage in trade except insofar as may be temporarily necessary in the conduct of its business or in the course of the transaction of debts due to it. No licensed financial institution shall be an affiliate of a company which does not conduct banking business or business of a financial nature unless the central bank grants approval. According to Section 54, a licensed financial institution may acquire or establish a subsidiary company with a prior written approval of the central bank, where the subsidiary shall be engaged solely in permissible activities as determined by the central bank. The investment of a licensed financial institution in a permitted subsidiary shall not exceed 10% of the capital base. The aggregate amount of investment which a licensed financial institution may take in respect of its subsidiaries should not exceed 25% of its capital base. Section 55 indicates the restriction placed on financial institutions in respect to purchase of property. The licensed financial institution shall not purchase acquire or lease real or immovable property except as may be necessary for the purpose of conducting its business as a licensed financial institution, including provision for future expansion and housing its officers and employees. In Section 57, every licensed financial institution may be required to maintain specified assets of an amount not less that from time to time determined by the central bank. Part 6 includes Section 59 to 69 and addresses audit and information. In Section 59, accounts and financial statements of a licensed financial institution or a licensed financial holding company, including financial statements on a consolidated basis, shall be in accordance with internationally accepted accounting standards, reflecting additional accounting rules or standards as shall be issued by the central bank. An external auditor shall report to the central bank on any matter it is investigating, simultaneously with its report to the licensed financial institution or licensed financial holding company. Part 7 deals with supervision by the central bank. This part includes Section 70 to 96. The central bank shall examine or cause an examination to be made of each licensed financial institution from time to time, or whenever in its judgment an examination is necessary or expedient in order to determine that a licensed financial institution is in a sound financial condition. The central bank shall conduct consolidated supervision of corporate groups to assess and, if necessary, require remedial action be taken. In Section 72, the prudential requirements to be applied on a consolidated basis include minimum capital adequacy ratio of Section 46, liquidity requirements of Section 48, exposure limits of Section, related party lending limits of Section 50, prohibition on payment of dividends or transfers of profit under Section 45. The central bank, pursuant to Section 75, with respect to any relevant person of a licensed financial institution or affiliate, may take the following remedial actions. Require the relevant person to reimburse the licensed financial institution for losses caused by any violations. Prohibit the relevant person from direct or indirect exercise of voting rights attached to shares of the licensed financial institution. Suspend the relevant person from his position with the licensed financial institution or declare him to no longer be a fit and proper person. Throughout that part, penalties associated with non-compliance are stated. The central bank will have the authority to remove directors and employees if it is determined that they were the cause of the demise of an existing bank. Madam Speaker, Part 8 addresses corporate governance. This part includes Section 97 to 113. Every person who is or is likely to be a director, significant shareholder, or officer of a licensed financial institution or licensed financial holding company must be a fit and proper person to hold a particular position which he holds or is likely to hold. The bill provides a list of practices to guide corporate governance. This section is new to the Banking Act, and directors, staff, and shareholders are all expected to operate within the specified guidelines and best practices. The board of a licensed financial institution or a licensed financial holding company shall ensure that the risk management policies and procedures include appropriate risk strategies and risk management frameworks to address the following risks: credit, country and transfer, market, interest rate risk in the banking book, legal and reputational risk, and operational risk on a bank-wide basis. According to Part 9, the central bank may appoint an officer an official administrator for a licensed financial institution or licensed financial holding company, where, among other things, it is determined that the company has violated any provision of this Act or regulations made under this Act or prudential standards issued by the central bank. On the appointment of an official administrator, all powers, functions, and responsibilities of the licensed financial institutions or licensed financial holding companies, shareholders, directors, and officers shall vest in the official administrator, except where the official administrator requests the shareholders or directors or officers to carry out any activity provided under this Act. Part 10 includes Section 138 to 157 and deals with receivership and compulsory liquidation. The central bank may appoint a receiver for a licensed financial institution or licensed financial holding company where it is insolvent, it is not viable, its capital is impaired, or its condition is otherwise unsound, it has experienced substantial dissipation of assets or earnings due to any of the grounds for action by the central bank, it or its directors, officers, employees, or significant shareholders willfully violate or fail to comply with an order or direction of the central bank, its business is being conducted in an unlawful or imprudent manner, the continuation of its activities is detrimental to the interests of its depositors, it conceals or refuses to submit any of its records or its operations for examination as provided. Madam Speaker, provisions for voluntary liquidation are contained in Part 11, which includes Section 158 to 166. A voluntary liquidation of a licensed financial institution shall be subject to authorization by the central bank when the licensed financial institution is solvent and has significant liquid assets to repay its depositors and other creditors within 3 days, and the liquidation has been properly approved by the members or shareholders of the licensed financial institution. The notice of liquidation will be posted conspicuously on the premises of each office and branch of the licensed financial institution and will be published at the central bank as the central bank shall direct. Part 12 includes Section 167 to 174 and focuses on abandoned property. Every licensed financial institution or licensed financial holding company shall within 90 days after the end of its financial year report such holdings to the central bank and pay to the central bank all property presumed to be abandoned listed in the report in accordance with regulations made by the minister upon the recommendation of the central bank. Except with the approval of the central bank on the terms and conditions as it may determine, no reduction in the amount of interest or dividends payable, and no charges in excess of those made in respect of comparable active accounts shall be made by a licensed financial institution or licensed financial holding company. The contents of a safe deposit box at a licensed financial institution shall be presumed to be abandoned where the lease or rental has expired and 5 years has elapsed from the expiration of the lease or rental. Madam Speaker, Part 13 deals with transfer of banking business, including Sections 175 to 177. Where an agreement has been entered into for the acquisition by a licensed financial institution of the undertaking of another financial institution, whether or not a financial institution to which the provisions of this Act apply, the transferor financial institution may make a written application to the central bank, notice of which shall be published in the Gazette in any case where the central bank so directs. Part 14. Part 14 includes the miscellaneous provisions and includes Section 178 to 193. The issues covered in this part include secrecy of information, Administrative penalties. Administrative penalties to be placed on the credit of the central bank. Schedule 3 offenses. Working days of licensed financial institutions and licensed holding companies. Provision for regulations to be made by the minister. Prudential standards. Court's powers in legal claims against the central bank. Breach financial institutions and asset management vehicles. Participate in government financing of transfers of deposits. Immunity. Non-application of Aliens Land Holding Regulation Act. Provisions applicable to credit institution, class of credit institution and financial group. Amendment of schedules. With this bill, Madam Speaker, the 2005 Banking Act is repealed. However, any regulation, rule, notice, or other subsidiary legislation or guidelines made pursuant to the Banking Act of 2005 shall, if enforced at the commencement of this Act, continue in force until replaced by any regulation, rule, order, notice, or subsidiary legislation made under this Act. Transitional provisions, Madam Speaker. The bill contains 4 schedules as follows. Fees for licensed financial institution, a list of various classes of businesses, offenses in respect of which liability to conviction may be discharged, notice of opportunity to discharge liability. Madam Speaker, I have tried to summarize some key elements of the bill. Government engaged in consultation with the banking sector. All banks were consulted, Madam Speaker. The bill was sent to them, and I also, along with the staff of the Ministry of Finance and the Attorney General and the Minister for Economic Development, met with the Banking Association. We also met with the National Bank bilaterally to discuss the provisions of the bill, to hear their concerns, hear their views on this legislation, Madam Speaker. We also wrote to all the private sector entities, the Employers Federation, DIC, DHTA, the Builders Contractors Association. We wrote to them, we met with them, roundtable discussion, heard their views. They gave us their concerns. Those were transmitted to the central bank for the attention of the Monetary Council. We also met, Madam Speaker, we also wrote the trade unions and met with some trade unions who responded to invitation to meet. We had discussions. We drew to their attention specific sections of the bill which deals directly with the staff and the responsibilities of the staff in this new legislation that they should be particularly concerned about and pay attention to. We had some very good discussions with those persons, Madam Speaker. A copy of the bill was also sent to the Leader of the Opposition with the hope that he would have discussed that bill, that document with his members, so if they would have some views, they would have submitted those views to the government in advance of the government coming to the Parliament to discuss and to debate this legislation, Madam Speaker. I also instructed, and the instruction was carried out, that the bill should be posted in the government website so that anybody in the world, any Dominican resident, who would want to visit the bill and to read it, would have access to it so they could make the comments to this, Madam Speaker. I said, all of those comments that have been received, those that were solicited and those that were not solicited, were all sent to the central bank for its attention, Madam Speaker. And I want to thank publicly, Madam Speaker, all those who participated in the consultation. I want to thank all those who came forward and engaged, Madam Speaker. But, Madam Speaker, this is a uniform piece of legislation, which means that in every member state of the monetary union, the same bill will be enacted by the Parliament. Notwithstanding the demonstrations in Antigua and Barbuda, for example, Madam Speaker, the exact legislation was passed in the Parliament of Antigua and Barbuda. It has been passed in St. Lucia, it has been passed in St. Vincent, it has been passed in Grenada, Madam Speaker. I believe Anguilla may pass it because it's a change of government, so they may go and pass it very soon. But, Madam Speaker, the main purpose of this bill, really, is to protect depositors and to ensure that good governance practices are adhered to and followed. Because in large measure, the challenges which we are facing in the banking sector in the region, Madam Speaker, had to do with certain actions on the part of directors and shareholders. And in some cases, staff members were part of this. So what this central bank, which is the advisory body of the union governments, Madam Speaker, is to look at the issues confronting the banking sector and to seek to capture those issues as far as practically possible in legislation. To avoid these things from happening in the future. And as I said, Madam Speaker, the same thing was done with regards to insurance. So while we'll all have issues with the bill, because I myself have expressed certain concerns I have with the bill with the monetary union. But at the end of the day, there's something called collective responsibility. So while, for example, we may not have those issues confronting Dominica now, but whatever happens in any other country within the monetary union will affect our system here because we're part of one single space. And so my hope is that we understand the fact that we have to take action. But we also have to understand that we are operating in a global environment. And if we do not send a very clear message to those who are engaging themselves in banking business, but also to those who we are doing business with outside of the union, that we are serious about taking action to prevent these things from happening in the future, we run the risk of losing our correspondent banking licenses. Because of the onerous stipulations imposed on banking these days, especially by the United States government, there are banks that are saying to us in the region, the entire region, from Jamaica down to Suriname, in respect to correspondent banking, that our jurisdiction is so small. The transactions that they do for us is so small in respect to other jurisdictions, that the hassle that they have to go through for those small transactions, that they are reviewing their relationships with us in the region, Madam Speaker. Thank you. And we have written to the U.S. government. This matter we raised when we met the U.S. president, and it's a matter we also raised with the French president that they need to discuss at the G7 summit in September, to draw to the attention the challenges confronting small jurisdictions like ours. But, Madam Speaker, this is an important piece of legislation. It may appear to be very intrusive, but when we're dealing with people's money, we have to ensure that we set aside our concern about intrusion. Because when people put their money into the banks, they expect when they go there tomorrow, the day after, the following month, that they can have their money, have access to the money. And that is the only objective here, is to ensure that the small people, the middle-sized people, the big people who put their money, their hard-earned money in the banks, their salaries and so forth, the deposits, that at any time they would like to have access to it, to deal with any issue confronting their family or their businesses, the money is there in safekeeping. And to ensure that there is no ambiguity, to ensure that there is consistency in the application of the provisions of the legislation. This is why you will see, Madam Speaker, in comparison to the 2005 legislation, the Ministers of Finance of the Monetary Union have delegated the authority to the central bank. So we say, look, you deal with these issues so that we do not have one Minister of Finance making an application on one way, on the same issue, and another doing the same, another issue, Madam Speaker. So let us have a central command, so to speak, where all of these issues will be dealt with, rather than individual jurisdiction, Madam Speaker. And so this is what you see here in comparison to 2005 legislation. Because, truth be told, there was some jurisdiction, Madam Speaker, where certain governments were not taking the action that they needed to take in addressing particular concerns. And we have a collective responsibility to ensure that we maintain a sound and well-regulated financial system. And in that case, the banking system, Madam Speaker. I want to thank you for allowing me the time to present.
The bill is now before the House for debate. I need to remind members that the name of the bill is the Banking Act. The latitude that members took to themselves when discussing the motion yesterday is not available, the Banking Act. So I'm asking members please to cooperate and ensure that their contribution to the deliberation is focused on the Banking Act. Nobody's willing to speak, but I think.
Thank you very much, Madam Speaker. Even as I rise to speak to a few issues on the Banking Act, let me, at this time, express my full support and solidarity with the people of Salisbury. In particular...
I don't think you heard me.
Madam Speaker.
We have a long day ahead of us, and I am going to keep strictly to the Banking Act. The Banking Act. Very strictly to the Banking Act.
Madam Speaker, with all due respect, the Honorable Prime Minister was allowed to address another issue outside of this.
That is something of national interest that the Prime Minister brought to the attention of the House. I am not allowing it. The member, you have to understand that I have to direct this House in a particular way for efficacy. And I'm saying to you, the Banking Act. I'm not going to say it again. I will simply ask you to take your seat.
Let me thank the Honorable Prime Minister for his efforts to involve the public in the discussion of a bill that I believe is intended to change the face of banking as we know it in the Caribbean. I appreciate the efforts of the central bank to move with speed to address issues that were highlighted and that came to the fore with the onslaught of the global financial crisis in 2008. It is important to note that while I understand the rationale for the bringing forward of this bill, as well as the importance of this to strengthening banking regulation and supervision within the OECS countries, it is also important to note that Sir Dwight Venner himself pointed to the fact that there were some imperfections in the bill. And the obvious question to us as parliamentarians is why not address some of those seeming imperfections? And I'll draw attention to a few of those. And with that, I can bring to bear over 15 years of experience in other jurisdictions, helping countries frame their own laws and issues with regards to banks. in some of the areas within the legislation, the language in my mind is not sufficiently tight, or it is ambiguous enough to leave it up to interpretation. Bear in mind that, that this act is to regulate banking business, and it is defined in section 3A. An immediate concern to me is the whole issue of the credit unions. We are told, and we saw a release, for example, from the Eastern Caribbean Central Bank, where we are told that the credit unions will not be regulated. Now, that raises an important concern for me here in Dominica in particular, because the role that credit unions play within the financial institutions here in Dominica is not the same role that they play in other countries within the OECS. And you would note that the credit union here is the second largest in terms of assets after the National Bank. So it seems to me that if, as the Prime Minister indicated, that this bill is intended to look after the interests of the depositors, that a significant number of depositors would be with the credit unions. So if the credit unions are not part of this, then the question is what kind of coverage are we offering to those who are operating within that space? And if they are, why is it not more clearly and explicitly stated within the Act? So I have this first issue. Another issue that I'm concerned about with regards to the Act is Section 50, which talks about the restrictions on borrowing, or the exposure to different classes of borrowers. And I note that the
50 or 15?
50.
50, thank you.
That has to do with the caps on borrowing by borrowers and different individuals. I was concerned that not enough was placed, not enough emphasis, or nothing was actually stated explicitly with regards to exposure to government. Because we know that in some of our jurisdictions, governments sometimes have a tendency to borrow excessively or borrow large amounts from, especially, the national banks. And I would think that with such critical legislation, that there would have been some mention or some cap placed on the level of government borrowing. So that I would like to see better addressed in this. Coming back to the issue of the bank and the granting of a bank license. Again, the legislation is not clear enough as to whether or not a banking license can be issued to an individual, and that is very important. Again, in most jurisdictions around the globe, it is clearly stated that they can only issue a license to an entity, not an individual, and that again is not clearly stated with regards to who can receive a license. The other important area with regard to the issuing of licenses and the granting of licenses is the whole aspect of the offshore banking sector. We know that Dominica is an offshore banking jurisdiction, and again, no explicit language within the Act to look at the relationship between the offshore banking sector and the domestic banking institutions. And that is important, and other jurisdictions have in fact done that, explicitly indicated within the legislation that relationship. I'll give you an example, which is the reason why I raised this. A few years ago, an offshore bank operating here in Dominica, the Griffon Bank it is called, operating at government headquarters in Roseau, it went under. There was a branch in Panama, and when this bank folded, depositors who had put the monies in the bank in Panama, they were told to go to the Dominica branch for their deposits. The question then becomes, is there a way, for example, in which an offshore bank that's operating within the space in Dominica, and you have Dominicans who are residents of Dominica who have been able or succeeded in opening accounts in those banks, whether or not that would fall under that jurisdiction. So again, I think that the legislation would have been helped if there was a clearer guidance there on this. Again, let me remind this Honorable House, Madam Speaker, that we are the Parliament of Dominica, and one of the things that we should be guarding against or guarding about is the whole question of revenues for the country. In this legislation, an important departure from the Act of 2005 is the fact that license fees will no longer be payable to the government of Dominica. These license fees will now be payable only to the central bank. I would like to take a different approach to this. I think if the banks are operating within our space, that whatever license fees should go to the government, and that is not insignificant. We are talking about close to $500,000 every year. And this money, I think, should really go towards the individual government, and in particular, Dominica, I think we need this very much. So I don't think that we should simply allow hundreds of thousands of dollars in potential revenues to simply bypass our treasury and to go elsewhere. And I'm not convinced that the central bank has made the case sufficiently as to why it is that license fees should be paid to them. There are other ways that the central bank can raise revenues and can make money from the whole banking arrangement. A critical issue, Madam Speaker, is that of the central bank as regulator. And with this, I will move to section 76. It appears to me that the rule, whilst it is commendable that the central bank seek to exert its influence as far as ensuring that the banks are well regulated, it seems to me that the powers granted within section 76 may be a bit too far-reaching. For instance, section 76, subsection G says that the central bank as regulator can, quote, suspend or remove any officer of the licensed financial institution or restrict the officer's powers. In the past, the central bank as regulator had some say with regards to the directors and the upper management of the banks. Now we are talking about the central bank as regulator being able to go in and actually have a say with regards to the ordinary employees of the bank. And the question is, isn't that too far-reaching a role that the central bank, and it could easily blur the line between serving as a regulator of the bank, and bear in mind as well, we're talking about a very small space still, and the people who work at the central bank may know the individuals operating within the bank and so on. So you have all issues that could come up there, and I suspect that this particular role is a bit too far-reaching. In fact, if we look at section 83, which is linked to this, the central bank can take action against a bank employee even where the person has been exonerated by a court. So for instance, an individual who is accused of wrongdoing within the bank, he goes to court, the bank finds him not guilty, the central bank can at that point move against this individual. And the question then becomes, aren't you overstepping the authority of the court, which is supposed to be the highest lawgiver within the land, and whether or not the central bank is overstepping its bonds there. Now, I'm no constitutional lawyer, and I will depend upon my astute lawyer colleague here to probably weigh in on this, but it seems to me that as regulator, that this particular section 83 allows too far a reach for the central bank. And this is something that we should really guard against. And the whole question of whether or not this can be done in an impartial manner. Now, Madam Speaker, on the very important issue that the Prime Minister highlighted, the issue of protection to individuals and to clients, that is something that in our space is of grave concern. To the extent that if tomorrow, God forbid, there is a run on the bank, if people lose confidence in the banking system and they want to take the monies out, whether or not they will have access to those monies if there are issues with the bank. I note that in the submission made by the Prime Minister, he indicated that this was addressed. In reading the Act, it appears to me that the way that this has been partially addressed or been attempted to is to raise the initial capital that the bank can give from $5 million to $20 million. That to me is not sufficient. I believe that we should be looking to a system of insurance for bank depositors, something along the lines of what exists in the United States and in other jurisdictions, where you have the deposits of depositors being protected on an insurance scheme of some upper limit, so that if there is a problem, we know that they would be at least be entitled to receiving that amount. So I don't believe that the law goes far enough to offering that kind of protection that is so critical, and simply increasing the share capital to 20 million is in itself not going to do this, especially when you consider that we have upwards of $500 million to $1 billion in liabilities that the banks have in terms of the holdings of depositors. So that is certainly not the answer, and I would hope that going forward that the bank would address its mind to offering that type of protection to individuals. Another aspect of this protection that I would have liked to have seen is the role that the commercial banking sector can in fact play in helping to spur growth within the country and in helping to generate activity, economic activity. We know for a fact that within our jurisdiction, there is a lot of, if you like, barriers within the central bank, within the banking system, that makes it very difficult for customers. So for instance, if a customer is late by a few months, the whole issue of compounded interest, to the point where the amount, let's assume a customer has paid a certain amount on a loan. Let's say he has a loan of $100,000, he's paid $50,000. Then he falls back on his payment for the extra $50,000. It would get to a point where he has to pay more than the initial amount of the $100,000 loan back to the bank if he falls back. And it becomes very difficult sometimes, and that's one of the reasons why we have such high, if you like, problems within the banking system. And I would like to have seen some caps being placed on banks with regards to the giving or the issuing of compounded interest on arrears in payments, and making it easier for customers to come out of this debt burden and service their loan. So in terms of giving confidence to customers, I think that is lacking in the bill, and this is an area I would really like to see addressed. Now, I know that the Honorable Prime Minister and in fact the Governor of the Central Bank they have stressed the need for speed on this and to pass this. But I'm thinking, Madam Speaker, in view of some of the critical, what I believe to be critical, because once this is set in stone, it becomes more difficult to change. It can again be subject to challenges and so on, because, for example, the credit unions can simply argue that they're not part of this bill. Okay, and we are told, in fact, I have a release here from the central bank itself, which says that they're not. All right, so these are fundamental issues that I believe that we need to address. And I would beg the indulgence of the House, if it's at all possible, to delay the final reading of this bill to see how we can address and if some of these issues could be addressed. And that I thank you, Madam Speaker.
Thank you, Madam Speaker. Madam Speaker, this bill this bill, Madam Speaker, I consider it an extremely important bill to the Commonwealth of Dominica. I would like to see the approach to this bill, Madam Speaker, be taken by this House, where members on both sides realize that it is not an opposition bill or government bill, but it's a bill for banking. And my comments here, Madam Speaker, will be in no way indicating my disapproval of this bill. And as a matter of fact, let me put on the record that I support strengthening legislations to take care of the banking framework in the Commonwealth of Dominica. I support this totally. But what I would like to see happen, Madam Speaker, is we should look through the bill and seek to minimize the work of the court later. Because if we allow loopholes within the bill, and if we are not firm on certain things within the bill, it can create opportunities for serious challenges. And we can correct some of those right now. So I would like to see the House look at these matters. We understand how some of the reasons why we have to be where we are today. And when we looked at the situation with Baiko and Clico, would understand that the central bank really should have some interest in the banking laws. When we look at what have happened in the US, we'd understand that IMF and other major institutions should have some issues with our laws. And when we look at what have happened in these areas and the effect it had on us, we should understand as members of parliament that we have a duty to protect the public, and we have a duty to ensure that people hard-earned monies are safe. As I look, Madam Speaker, through this bill briefly, because I must state, Madam Speaker, that it's not the smallest bill, and there's a bit of reading, but I tried my best to run through it. What I've noticed, Madam Speaker, for example, throughout the bill, financial institution, the term financial institution is right throughout the bill. But when I look to the interpretation section, Madam Speaker, I could not find a clear definition right in there for the term financial institution. And I think we need to look at that because it is a critical term throughout the bill, Madam Speaker. Under section 2B, where it states that the banking business means, and I go on the B, any other business recognized by the central bank as banking practice and which a licensed financial institution additionally be authorized to do. Madam Speaker, I'm concerned that we are giving too much latitude to the central bank in that section. I think it is clear that we have internationally accepted standards, and it should not be left to the central bank to be the one to make that decision. We should go with internationally accepted standards, and that would help to minimize the problems that we possibly can see upcoming in the future, Madam Speaker. I refer, Madam Speaker, to section, and I'm going to try to run quickly, Madam Speaker, section 3, subsection 5, which speaks to the penalties, Madam Speaker. The penalties are in two parts, Madam Speaker, for the individual and for the organization institution. The government may want to look at the possibility of really assigning a single penalty. If it's to the institution or to the individual, rather than having a double penalty, they may want to look at having a single penalty on this matter. Section 8.4, Madam Speaker, which has to do with granting or denial of licensing. It is our feel, Madam Speaker, that that section is boxing the central bank into dealing with applications, because it says that within 6 months of its receipt of a completed application for a license, the central bank shall either, and it gives you two options, grant the license or refuse to grant the license. The question is, after 6 months, if the central bank did not grant the license, what happens? Because is it that at that point the license can be considered granted? Is it that the institution should reapply? No, but what I'm saying, Madam Speaker, it gives us 6 months window, but it's not saying what should happen outside of that. And as I said, Madam Speaker, I'm raising this as genuine concerns. And, you know, they want to leave it as it is. They want to look at some changes. But one can argue, well, if you have 6 months and you have not replied to me in 6 months, I should consider myself in receipt of the license, or I should consider the license not being issued. Or one may say, look, should I reapply after that? So I'm saying, Madam Speaker, it's a matter of concern. I've noted it, and I just wanted to put on the record as one of the matters that I have some concerns with. 10.2, Madam Speaker. Which deals with the license for financial institutions, and it goes on to say that any other service that the central bank may determine as banking practice. Again, I'm saying, Madam Speaker, it goes back to the concern I had under establishing banking business. Because if we use the standard established international standards and practices, Madam Speaker, then we would not be leaving that to the central bank to establish that. So I'm really bringing this here, that section again, Madam Speaker, to show that there should be some concerns with respect to the amount of latitude that has been allowed to the central bank. In section 14, Madam Speaker, which has to do with the revocation of license, it states that if a license is revoked, it should be published in the Gazette or in the local newspaper. Now, we are speaking of a currency union. So, we are not speaking as in the ULAC, as in Dominica. We are speaking of currency union. The question is, a bank license is revoked in Dominica. Would individuals in Grenada have any interest in that? Should there be an opportunity if there's an operation out there? Should there be an opportunity for it to also be published within the union rather than just in Dominica stated in the Act? Okay? And I'm also suggesting, Madam Speaker, that we may not want to say the Gazette or the newspaper. We may want to say the Gazette and the newspaper so that we allowed sufficient information to be out there with respect to revocation of license. It also says in 6, Madam Speaker, that the bank should act as soon as possible. And we may want to, like we did in the earlier section, put a specific time into which the bank must put the information out there. Section 16, Madam Speaker, where it reads, 16(4)(b), where it reads, Madam Speaker, and it has to do with restricted words, names, or practice. No person other than a licensed financial institution shall accept with a written consent of the central bank, and B says, in any manner solicit, receive, deposit from public or any employee or that person. Madam Speaker, I don't know, and I will leave it to the Attorney General to guide us on that, whether that is not really bordering on infringement of the rights of investors to solicit support or injection of funds into the operation. I'm a little concerned with that. I would like to hear what the Attorney General may have to say about this section, really, because I feel that it is sort of squeezing business people into a corner and having the central bank with its powers having to make some very, very, very pertinent decision for the business sector. And it can really hurt. It may not hurt today, but down the line it's in the laws. And when it forms the law of the Commonwealth of Dominica, it has the potential to hurt later. Under section 44, Madam Speaker, and I'm speaking to 44 subsection 1B. This section, Madam Speaker, is obviously creating a single financial space. But at the same time, Madam Speaker, in B, it speaks of the minimum paid-up capital for every license or credit financial institutions in Dominica. And I'm wondering whether the intention of this bill is to rope in institutions, small institutions like Big Edge and Fast Cash, which operates in Dominica. I'm wondering if that is the intention of this section. And if it is, madams, I'm speaking to section 44(1)B. And if it is, Madam Speaker, it can have some serious implications for the poor person on the street who really needs their little $1,000 and $2,000, because it would challenge these small organizations to operate. So it is something, again, and my thinking is if we are going to put forward this act, let us take all of Dominica into consideration and let us try to do the best at this point in time, and let us have a common understanding on it. If so be the decision to go down that road, I respect, but we should look at it to see whether it will have some negative implications and what can be done, if there's anything else we can do to adjust that, Madam Speaker. Section 55(3), Madam Speaker. Restriction on investments in real property. Madam Speaker, again, I am concerned that this section will be giving the institutions extreme powers, because my understanding of this section, Madam Speaker, is that, and let me just read it here quickly, 55(3). A licensed financial institution may secure a debt on any real or immobile property, and in default of repayment, may acquire the property for resale as soon as possible. Now, I am concerned, Madam Speaker, of that type of authority that you're giving into the institutions. Why? Yes, I understand it is their monies. Yes, I understand that there may be a mortgage on those properties, but, and whilst I understand that it is challenging to acquire the properties right now because of the court system, I don't know if we really want to go down the road to give the institutions that type of authority at this point in time, Madam Speaker. So again, it's something that we may want to look at and see how best we could address it. Section 68(1), Madam Speaker. It says, and it has to do with failure to comply with a request. A licensed financial institution or holding company which fails to comply with the request under section 2B is liable to a penalty of, and it says the amount of $100,000. A director, Madam Speaker, the concern here is that the person who has failed to do that would be losing their job anyway. All right? The person will be losing the job. So the person is losing the job because of their failure, Madam Speaker, to comply. But then the person is faced with a penalty after they have lost their job. The person have already, that in itself it's a penalty. So again, Madam Speaker, I'm throwing it out there, and we may want to look at it. If we feel we want to go ahead, Madam Speaker, yes, we can, but I think we may want to also look at that section. Removal of directors under 101, Madam Speaker. It says that the central bank may issue the reasons. I would like to suggest, Madam Speaker, the assignment of a director is a serious matter to any institution. We're speaking of the monies of individuals, of corporations, and I'm not comfortable with the central bank refusing a director and not forced to say why. So I am saying we may not want to look at the word may. We may want to say the shall, because they really should say why they have refused this director, Madam Speaker. As I wind up, Madam Speaker, I noticed that 186 and 187 allows for the bridge financial institutions, and as we looked at what has happened with the CLICO situation where we have had serious losses nationally, one of the members of government may want to indicate whether the government intend to provide assistance under this section to relieve the pain of the people who have lost these monies in this company. Madam Speaker, the decision for banking in Dominica lies within the hands of all of the individuals in here. If there's no banking, we have some problems. Every individual alive in the Commonwealth of Dominica will be affected whether they are going directly to the bank or indirectly to the bank, because if they don't go directly to the bank, the persons who are going directly to the bank to take a loan to open a business, serving them. So they will all be affected. I ask of this House, I beg of this House, that we spend some time, look at some of the issues that will be raised here today, and seek to see whether it's possible that we may want to look at a short deferral of this bill, Madam Speaker, to ensure that we have it done right for the people of the Commonwealth of Dominica. I thank you, Madam Speaker.
Thank you, Madam Speaker. Madam Speaker, I rise to support this legislation. I would also, this bill, sorry, I would also like to commend the Honorable Prime Minister for the time taken in explaining the main provisions of the bill and the indication of the level of consultation that was undertaken by the government with respect to the bill. Madam Speaker, as I've always indicated in the House, that when I stand up to speak on an issue, the fact that I may bring out points in there doesn't necessarily mean I do not support the issue. It's just that I wish to bring out issues that may be necessary for consideration of the House as before approval of whatever is before us, as I did yesterday. I would like to speak, Madam Speaker, to just about 3 points in the bill there. In particular, I would like to speak to Section 153, priorities in payment of claims. The Honourable Prime Minister indicated that they consulted with the unions before the bill was taken to the House, and also that it has been passed in 3 islands, including Antigua. I did speak to bankers up in Antigua, friends I have up there, and to ask how this measure went through the House in Antigua. And they did point out to me that this particular section was of concern, that Section 153 in particular, subsection F, that is the determination of priorities in payment of claims with respect to institutions in receivership or compulsory liquidation. And it's at Section F, it says that with respect to the employees, that the national insurance contributions for officers and employees is due but not paid. And we have to raise the issue about if there are claims of severance and gratuity with respect to the employees, whether this should be of concern and whether we should make it explicitly clear that such claims should be paid before shareholders are paid. And this is important, Madam Speaker, particularly the same section applies to voluntary liquidation, where there is not enough assets to meet all the responsibilities of the institution, that this section also applies here. So we have to ensure that the employees who may be innocent, all they did was to give a fair day's pay, work for a fair day's pay, have them found themselves in a situation where they are no longer employed, and yet some of the benefits they have, there will be problems for them to receive it. subsections 3 and 4, one might argue that the claims can be made under these sections. However, Madam Speaker, that might require long litigation and costly to the employees or the union try to make that claim. So I would suggest and recommend that we situate that that section is amended to ensure that claims of that nature are paid to employees before shareholders receive whatever is left of the such institutions. That's just a recommendation. Madam Speaker, I would also like to speak to section 55, which deals with restrictions in investment in real estate, section 55. My colleague here, Dr. Fontaine, touched on it very briefly, but I would like to speak to it specifically with respect to home mortgage. We know, Madam Speaker, what can happen to persons, what could cause them to default on their mortgage. Yesterday we heard of the number of persons who find themselves in situations where because of the medical bills that they're not able to meet these commitments. We find ourselves, you can find that persons in a two-income household, because of divorce or whatever, they end up being in one income, and they're not able to meet their commitments to the bank. And the legislation provides that within 5 years of such situations where the bank takes possession, they must dispose of the property. We are aware of this situation, Madam Speaker, that this section must be read probably together with the Title by Registration Act and the problems that sometimes it delays in having the foreclosures completed. But what has been faced by many persons and homeowners is the fact that they are faced with high legal fees and charges and compounded interest under those situations. Another problem they face, Madam Speaker, is that the attorneys have the tendency, when these such properties are in foreclosure, they keep it and they don't send it out to real estate so that it can get maximum exposure and quick sale. And by the time the period comes into play, you find that the value of the property, the market value of the property goes down so much because there's no maintenance. So we need to make sure that there is regulation. There's regulation to ensure that the borrower, especially home mortgage homeowners, because, Madam Speaker, in these islands and in Dominica, the large of your investment, your life investment is put into your home. And therefore, you want to make sure if you're passing a banking act, we put the maximum protection for persons, for the people and homeowners who are faced with a situation where there's foreclosure and that they have to lose their property. And especially in the light of this section, we do not want a situation where the bank, because the law says that you have to get rid of the property within 5 years, that they might have the tendencies that they might sell it below market value, and then the owners lose property. So I would hope that we can pay some attention to this section and see whether we can strengthen it and to protect the homeowner. The only last section I would like to touch on, Madam Speaker, it might sound a little bit political, but it's not intended to be political, is section 95, where the central bank is required to give to the governments reports or statements that if the government requests for it. And the section provides for secrecy. Madam Speaker, I was not even a member of this House when I was a victim of the lack of secrecy with respect to my banking activities, where details of my banking activities was revealed in this House, to my dismay, to the point where I had to write to at least one of the institutions involved, asking why such information got into the House of Assembly and in the public domain. I just want to raise it, Madam Speaker, that we deal on a trait, and as politicians, that we are not get tempted to abuse the authority where situations we find ourselves we do not like, certain situations where we can use information that we receive in a private capacity or because of our office, and we disclose it. The section provides the protection, and I would hope that we respect that protection and secrecy. because I've been a victim of that situation. I just want to highlight it. Thank you, Madam Speaker.
Wait, it was still up, man. Let's run it short, man.
No,
I held
sorry,
up the department. I know you have to travel over the weekend. I could not hear today, so you can speak. But you speak now, man. Huh? But that's good. That's good. That's good. Because you know what I'm going to do? Madam Speaker, through you, just to remind the Honorable Prime Minister, yes, I will be in Jamaica next week at a World Bank-sponsored conference on transparency, good governance that is happening in Kingston. Mr. Prime Minister, thank you very much for your presentation this morning and for the consultations, I understand, preceded the presentation of this bill before the House this morning. I myself, as you have indicated, received a copy of the bill. It was not too long ago. I don't remember it being too long ago because I was trying to read, and while I was trying to read it, the Parliament was called. So I'm not sure how long it came before that, but I've read it. My colleagues have had their read of it, and in principle, Mr. Prime Minister, we support this legislative initiative to essentially to protect the depositors of the Eastern Caribbean Currency Union. This is an act to provide for the regulation of banking business, the establishment of a single banking space, and for incidental and related matters. And it also provides, Madam Speaker, through you, for the repeal of the Banking Act number 16 of 2005. And what this presentation of legislation before the House today tells us is that where you have a law in the Parliament that makes certain provisions that you no longer want to apply, you are required to bring new legislation that repeals the one before. I go back to what I suggested yesterday, using the occasion of debate on this Banking Act to suggest legislative amendments to bring into full effect the name change, which was decided by cabinet decision of October 2007.
You can go back and discuss what was discussed in an act that has passed, that you can do this. So,
Guided, Madam Speaker. This is, as the Prime Minister indicated, harmonized legislation for the Eastern Caribbean Currency Union. I put it to this House that it is harmonized legislation in circumstances where there is disharmony in the economic management capabilities and the economic performance of the ECCU member territories. For perspective, Dominica is not particularly competitive with the rest of the group in terms of GDP growth in the last 15 years, inflows of foreign direct investment, employment creation, and foreign exchange earnings. And accordingly, under the broad sweep of this act, there is a unique challenge facing Dominica and by extension the Parliament of Dominica, and I will come to that point in conclusion. Now, this act references the agreement establishing the Eastern Caribbean Central Bank on the 5th of July 1983, and in the context of regulating banking business, it concerns itself, Section 2 definition in terms, not just with the leadership and management phases of day-to-day banking business, but with affiliates of financial institutions,
holding companies, licensed financial holding companies, related parties, significant shareholders, as the Prime Minister mentioned in his presentation, and also subsidiaries and ultimate beneficial owners of these financial institutions. And I want to say that Part 8 of the Act, which focuses on corporate governance, is my favorite part of the Act. It underlines the need for the banking business to be in the hands of fit and proper persons as determined by the Eastern Caribbean Central Bank, the regulator of the ECCU banking space. The Prime Minister has advised us that it was the decision of the finance ministers of the Monetary Council to fully transfer authority for licensing, for regulation and supervision of the banking space in the ECCU to the Eastern Caribbean Central Bank. And that matters like the granting and the revocation of licenses, which were previously handled by the finance ministers of the region, will now be the exclusive preserve of the Eastern Caribbean Central Bank. This is huge. This is huge. It is huge because we're moving from finance ministers to the Eastern Caribbean Central Bank for the overall management and almost, you could say, custodial responsibility for the banking space in the Eastern Caribbean Currency Union. I want to refer to Section 97 of this Act. And in Section 97, the focus is on corporate governance. That's Part 8. 97(1) tells us every person who is or is likely to be a director, significant shareholder, or officer of a licensed financial institution or licensed financial holding company must be a fit and proper person to hold a particular position which he holds or is likely to hold. 97(2) says, in the determination whether a person is a fit and proper person to hold any particular position, regard shall be had to A, the person's probity, competence, and soundness of judgment for fulfilling the responsibility of that position. B, the academic or professional qualifications or effective experience in banking, finance, business, or administration, or any other relevant discipline of the person concerned. C, the diligence with which the person is fulfilling or likely to fulfill the responsibilities of the position. And D, whether the interest of depositors or potential depositors of the licensed financial institution are or likely to be in any way threatened by the person holding the position. I welcome these. Our team welcomes these provisions on good governance. And 3C, addresses engagement in business practices appearing to be deceitful or oppressive or otherwise improper, whether unlawful or not, or which otherwise reflect discredit on the person's method of conducting business. 97(3)E is about whether the person involved in the conduct of banking business and engaged in or has been associated with any other business, practice, or otherwise conducted himself in a manner as to cast doubt on his competence and soundness of judgment. This matter of soundness of judgment, which the Banking Act of 2016 seeks to legislate into the financial space from the standpoint of leadership and management, I believe, and we believe on this side, is very important to us as stewards of the people's business in Dominica, and Parliament, and parliamentarians, because we cannot be coming to this House today to agree on this Banking Act of 2015 and to align ourselves with the requirements of soundness of judgment and not ourselves be examples of sound judgment. So, Madam Speaker, through you, I don't know why I was anticipating that response from the Honorable Prime Minister, but I speak for myself in terms of this Banking Act that is being presented today and the theme of soundness of judgment that is being treated for the leadership and management responsibility of the financial space in the ECCU. I also feel that to the references made, like to holding companies, for example, and the fact that the Banking Act provides you could have a holding company that could own a bank, and prior to this piece of legislation, 2005, for the legislation of 2005, you could have your bank operating, and you could be in your holding company, they could be separate and distinct. The bank would be, the regulators would be concerned about your banking business as opposed to your holding company. As of now, and the passage of this legislation, the bank would be concerned with the holding company as well that owns the bank. The regulators will be concerned with the holding company that owns the bank as well. Holding companies, Madam Speaker. And then we talk about soundness of judgment. I bring to this House today the example of a holding company called My Dominica Trade House. It is a holding company that operates in Malaysia, in Kuala Lumpur, Malaysia, but is said to have business interests in the Commonwealth of Dominica.
Relevance of what he's saying there, because I really do see it as part of the Banking Act that we are dealing with. I know you tried your best to maneuver something in, but I'm not having it. I said, it appears to me that you're trying to bring in something here that is not relevant here. I don't see it as relevant at all. We are dealing with provisions in the Banking Act.
Okay. Yeah, Madam Speaker, we're dealing with provisions of the Banking Act.
That's right.
And this Banking Act,
yes,
was presented to the Honorable House of the Commonwealth of Dominica,
yes,
by the Prime Minister and Minister of Finance of the Commonwealth of Dominica,
yes,
who appears to know something about a holding company in Malaysia
no. Wait a minute. Who appears to? The Prime Minister is right here. Why don't you have a private conversation with him and ask him if he knows? But you can't be doing that. You are casting aspersions, and I'm not having it.
No,
the member, I said before, and I'm saying again, we are not going left, we're not going right, we're going straight ahead. We've had brilliant contributions from the members so far dealing with the provisions of the Banking Act. This is what we are dealing with. Can we move on, please? I don't want any hypotheses, I don't want any suggestions, other than how can we change this to make it more effective for it to benefit the shareholders, the depositors, etc., etc., etc. And the member for Salisbury. That's all I'm saying for now.
Madam Speaker, I only felt that in the context of the Banking Act of the Bill for Banking Act 2015, which is before us today, there are some examples of legislative initiatives that are coming in this bank to give better leadership and management control, regulating leadership and management control of important spaces that could apply elsewhere. I will leave that and move on. Much obliged. This Banking Act 2015, we understand, came out of a Monetary Council meeting, Mr. Prime Minister, through you, was in February of this year. As a result of financial institutions which have found themselves in crisis in the currency union. You have the National Bank of Anguilla, which is under Eastern Caribbean Central Bank control. You have the Caribbean Commercial Bank of Anguilla under Eastern Caribbean Central Bank control as well. And under Eastern Caribbean Central Bank direction, you have the Eastern Caribbean Amalgamated Bank in Antigua, and you have the Antigua and Barbuda Investment Bank. These banks, we understand, have severe liquidity issues, which were brought about by heavy non-performing loans and or investments in affiliated group companies that are not performing. Now, what we understand is that the Eastern Caribbean Central Bank is unable, under its current treaty obligations and restrictions, to be a lender of last resort to these banks without control to force operational effectiveness changes within the bank. So while the ECCB has the mandate to ensure the safety and the soundness of the financial system, it finds itself handicapped under the provisions of the 2005 Act here in Dominica, for example, to effect necessary changes within the bank outside of an outright revocation of licenses, which itself could cause some risk throughout the system. So, reading through the legislation, the plan is for banks in that situation of crisis and tight liquidity to divest their non-performing assets into an asset management company. The legislation provides for that. The asset management company, of course, has not been formed. And to have that corporation pay for the assets with fresh liquidity back into the banks. The asset management company, it appears, will receive funding from the government and perhaps more from international agencies like IFC, World Bank, IMF, and so on. And the asset management company will then dispose of the assets so that the cash can be returned to the funders. This act is allowing the banks to acquire assets from non-performing borrowers, and those assets will be held on the bank balance sheet for up to 5 years, after which they can be disposed of. That's provided for at Section 55(3). The Act also places immediate restrictions on banks, the ability to acquire real property that is not for the use of bank activities. The reference here is to Section 55(1) and 2. We have as well restrictions on exposure to related parties and employees is Section 50 and 51. These restrictions some view as facilitating the liquidity challenges, depending on how you look at it, or exacerbating them on the other hand. And significantly, this act creates a single space for the flow of capital through the licensing requirements. It also increases significantly the capital requirements to obtain or to maintain a banking license. That is Section 44 of the Act, and I want to quote the provisions. 44(1), every licensed financial institution shall maintain in Dominica, unimpaired, paid up, as the case may be, assigned capital at least equal to the minimum amount specified in accordance with the following requirements. A, if operating as a bank, the minimum required capital shall be not less than $20 million. And if operating as a credit or other financial institution, the minimum capital requirement shall not be less than $5 million. The provision for operating as a bank and the new capital requirement of $20 million under the 2005 Act, that was $10 million. So effectively, that capital requirement has doubled. There's a concern about that I will come to in just a moment. The capital requirement will very likely force many, if not all, of the indigenous banks in this ECCU jurisdiction into an amalgamation. You have perhaps one of the banks in the region in this ECCU that could survive standing on its own. The banks, on the urging of the Eastern Caribbean Central Bank, have already agreed in principle on this way forward. And we have had some unofficial discussions with conversations with certain people at the bank and certain leaders of indigenous banks in that regard. That's going to mean, though, that the banks now would become branches with some central leadership and governance structure in the currency union. And with a single licensing arrangement, you would have the banks now moving capital within their own structure without even reporting separately as is required now under this Act with individual licenses. Capital in the banks, therefore, will move where credit conditions are more favorable. And that, of course, no surprise, it's a natural order of business. But you have a situation where, take the National Bank of Dominica, which has a 30-plus year history of building its capital base, its liquidity position, and having some cash on hand in the new environment. The capital available from ECCB will likely, capital available from NBD will likely move to more attractive areas of the ECCU jurisdiction. At the same time, the Dominicans looking for jobs that will be created, economic opportunity that will be created by the capital that moves from Dominica. These individuals may not be able to move as freely as the capital, following it where it goes, and you may have a situation where what we have struggled hard to build in Dominica and to develop is financing developments elsewhere while we are struggling to create employment for the people in Dominica. It's a real situation that requires us as parliamentarians now to put our heads together and to determine how is it we are going to function optimally in this new environment, because make no mistake about it, it is a new environment. The way banking has been transacted before is changing with the passage of this legislation. I believe largely for good. But it presents us with some challenges. I heard the Prime Minister, through you, Madam Speaker, indicating in his presentation that he had some concerns which he has spoken about. Notwithstanding those concerns, he is prepared to move forward with this piece of legislation. For us, we want to see this legislation come onto the books. But we would hope that some changes can be made. We already have examples where in Antigua, you had strikes over the 153 provision there for compensation benefits on termination for ordinary employees in the bank. And as I understand it, a promise was made that the legislation would be amended. Now, to the Prime Minister's point, and this is important, this is harmonized legislation, so we want to see the same thing across all jurisdictions. There was a promise. Okay. Madam Speaker, through you, I want to emphasize this point, that while a promise was made, the legislation remained the same. This now presents an issue, because if you look at Schedule 2 of the Act, Schedule 2, where banking, the business of a financial nature is dealt with, it says, business of a financial nature includes the following types of business. And if you go to 2, you will see credit unions. So this act that we're putting before the Parliament today tells us at Schedule 2 that credit unions represent business of a financial nature, provisions of basic savings, share accounts for members, and making loans to members. While this act has been making the rounds, and while there have been consultations on this act in the member territories of the Eastern Caribbean Currency Union, a concern surfaced in relation to this. The central bank has issued on its website a clarification that says credit unions in the ECCU will not be regulated under the proposed banking bill. And it goes on to say later on, credit unions conduct business of a financial nature, but they do not conduct banking business and are therefore not regulated by the ECCB under the existing Banking Act and will not be regulated under the proposed banking bill. Credit unions are regulated by the single regulatory units in individual ECCU countries under the Cooperative Societies Act. So this correspondence from the bank is very clear. Makes you wonder, if that is the bank's intention, why wouldn't the harmonized legislation be clear as opposed to ambiguous on this point? And so, Mr. Prime Minister, I accept that word of mouth or promise and a legislation are two separate things. The legislation is what is going to determine what goes on, not the promise. Similarly, the statement from the Eastern Caribbean Central Bank.
You have 3 minutes left.
Thank you, Madam Speaker. Thank you, Madam Speaker. We have credit conditions, and those credit conditions are directly related to growth, real growth in the country. It will remain weak, or it will become weak. In circumstances, the local private sector will have challenges accessing capital domestically and may not qualify to access credit regionally given our demographic. I'm pointing to challenges that are likely to surface as we take this forward, as we act as a group of parliamentarians in Dominica in the interest of depositors and the interest of strengthening and better managing the banking space in the OECS. We are concerned about stifling domestic business activity, starving it of credit, and creating further welfare burdens on the state and on the tax pool that contributes to the operations of the government of the Commonwealth of Dominica. Like I said, we support the bill. We would have hoped there would have been more time for the wider public to get involved in this so that holders of mortgages and so on could have a better idea of how they're going to be impacted. But I guess we together, speaking to the media, whether it is on Q95 or it's on Kyrie FM, will do the required education so that the people are better prepared for what is coming. Because this bill will change the environment for banking and by extension for doing business in the OACS region. Thank you.
Madam Speaker, I rise to give my unequivocal and uncontaminated support. To the banking bill which is before us, to the Madam Speaker. Madam Speaker, clearly, given the current state of affairs in the financial market, the global financial market, something had to be done to maintain the credibility and stability of the Eastern Caribbean Central Bank. And therefore, the new banking bill is fitting in that it has given, or it seeks to give the Eastern Caribbean Central Bank certain powers which will further strengthen the bank, and we must welcome that. Furthermore, Madam Speaker, of course, we support the idea that the bank wishes or wants to protect depositors. And on that note, Madam Speaker, you heard my colleague, Senator Dr. Thompson Fontaine, speaking of credit unions, because of course, in places like Dominica, Madam Speaker, the credit union has a very significant role in the financial space. Hence, while the Eastern Caribbean Central Bank has placed this bill before us, we are making a call that there will be a move to harmonize the credit union movements in the entire Eastern Caribbean, because depositors are not only at the commercial banks. On that note, Madam Speaker, we wish to also call for regulation of smaller financial institutions, because there are financial institutions providing financial services, and we must pass regulations, or they must be regulated, Madam Speaker. They must be regulated. Financial institutions such as Big Edge and Fast Cash must be regulated to protect those who are doing business. But Madam Speaker, one of the areas that I wish that the banking bill would capture is the area of consumer protection provisions. Madam Speaker, while the bill talks about protecting depositors, however, there are other concerns that consumers of financial services have as it relates to the banks. You heard my colleagues mention about mortgages. While the banks have contractual agreements as far as mortgages are concerned, Madam Speaker, you must admit, and this Honorable House must admit, that sometimes there are certain outcomes at the banks which appears to be very oppressive. How do we explain somebody who has a principal balance of $26,000 after 3 years have a total balance of $200,000? Because the accruing interest is allowed to accumulate without any barrier. So in that respect, Madam Speaker, we are saying that the Eastern Caribbean Central Bank has an opportunity, or would have had an opportunity, in designing this bill to have far more reaching consequences as far as affecting the life of the grassroots person. Because in as much as the bill seeks to strengthen the financial space, we have to keep in mind that the ordinary person wants to feel that the central bank is acting in his interest. And we understand that mortgages are based on contracts, but nonetheless, we have the view that the banking bill could provide provisions which could help to protect mortgages from what I consider to be oppressive terms and conditions. Furthermore, Madam Speaker, as far as conflict, and I'm talking about consumer protection, we are hearing stories such as conflict of interest, Madam Speaker, where bank workers or their family purchased foreclosed properties. And I'm saying this to say, Madam Speaker, that the bill could speak clearer in that respect. An entire provision simply dealing with consumer protection. Madam Speaker, I think that would help as far as ensuring that customers feel empowered in terms of the relationship with the banks. So, Madam Speaker, another area of concern is that the bill seeks to give the Eastern Caribbean Central Bank almost absolute power, in that the bank has the power to issue license, revoke license. It has power to fire workers, even when it does not have the power to hire. So in that respect, Madam Speaker, while the bank seeks to protect us from employers at the banks, we must be careful that we're not creating a monster, in that it does not get to a point where it starts to abuse, because we know that absolute power corrupts. And the bill is giving the Eastern Caribbean Central Bank a lot of power, to the point, Madam Speaker, if we look at Section 83 of the bill, it would appear that the bank is playing the role of judge, jury, and executioner, when it says that even where somebody may be exonerated or acquitted in a court of law, that the bank can still go ahead or may go ahead to take certain course of action. Madam Speaker, that has to be an area of concern, because it would appear that the bank wants to fetter the jurisdiction of the courts. So I'm saying that in as much as we support the movement to stabilize and improve the credibility of our banks, we must be very careful that we're not giving too much power, because that power could come back to haunt us. So in that respect, Madam Speaker, I'm putting this on public record, that if something like that were to happen, that we would have been warned. And I understand that the legislation can be amended. And though we had limited time, I hope we do not just take the legislation and place it on a shelf and forget it. I think that is a work in progress. That in as much as sorry about that, Madam Speaker. So, Madam Speaker, we are saying that in as much as we have limited time, and I commend the efforts to consult with the public, though I must admit that I am not too sure how much the ordinary person in Dominica would have learned about this banking bill. So as I'm saying, it's work in progress. I am hoping that we continue to discuss the banking bill, and I'm sure we'll identify the imperfections, and we'll do the right thing, that is to come back here and make the necessary amends if necessary. So, Madam Speaker, overall, as I've said, I support this banking bill, but in finality, my main concern has to do with the powers, that the central bank does not become abusive. And secondly, I think that honestly that the bill should have captured an area dealing with consumer protection. Thank you, Madam Speaker.
Madam Speaker, I rise to give full support to the proposed banking bill, or Banking Act of 2015. I give full support in recognition that the OECS financial space is relatively small, and therefore I would like to commend the ECCB for taking a step in the right direction, and also like to thank the Prime Minister for explaining the level of consultation that has taken place so far. But as my esteemed colleague said, it is a work in progress, so we have to continue the effort of explaining and discussing. Madam Speaker, I recognize in the proposed act that the use of a minimum capitalization to protect the depositors as is really outlined there. But I think it would be better if, in regards to insurance on a particular level of savings, for example, if, we could place insurance up to 100,000 for our bigger depositors, that would help. Now, in regards to the section that deals with interpretation, I'm very concerned in regards to the clarity where it deals with credit unions. Under interpretation, it says that the business of financial nature means the collection of funds in the form of deposits, shares, loans, premiums, and investment of such funds in regards to loans, shares, and other securities. However, when we move to Section 2, Schedule 2, Section 2, there's a credit union outlined there. So I think that in the Act, it would have been better if we actually clearly state whether the credit union is excluded, rather than a note from the governor of central bank expressing that it is excluded, because it is confusing, because it is in the interpretation, it speaks about deposits and savings, and under the schedule, it is actually naming the credit union as one of the financial institutions that conducting business. Also, Madam Speaker, although I am a person who would like to encourage market forces to determine what happens in a particular space, in recognition of the size of our market and the fact that this legislation will force consolidation, it would indirectly lead to less competition, especially at particular segments in that space. That is a lower segment, but I'll explain that. I'm proposing and encouraging the drafters to consider whether we can look at the portfolio mix and legislate. For example, although you might not want to force the commercial banks, but you have to consider that the commercial banks are really making money off of the people of Dominica, and maybe we should consider putting a particular percentage of their portfolio to go into the productive sector loans. One might argue that the development banks can take care of that. But again, I think we should consider it in the Act. It doesn't have to be a large percentage. But in regards to the portfolio, if let's say, for example, you have a portfolio of, let's say, 100 million, just giving an example, should we consider 1% of your total loan portfolio should go into the productive sector? I think we should consider that. Also, I would like to point out that under Section 44(1)(b), it says that a creditor or financial institution shall be a minimum of 5 million. Again, in keeping to the same argument that we want to encourage competition, I think we should consider within that financial space that we could look at, instead of 5 million, bring it down to more like 1 million. So it would encourage new players to come and to develop and to be able to look at, for example, microfinancing. Although the bigger players might be involved in microfinancing, but you want to encourage competition and not use, for example, a higher capitalization, which could be a barrier to entry. In addition, when we look at Schedule 1 of the Act, where it says fee for licensed financial institutions, I would like the drafters and this Honorable House to consider whether it would be more prudent to look at, in regards to the actual fees payment, whether we should break it down in a percentage, where, for example, the ECCB gets 25% of the total revenue, and the state, Dominica, gets something like 75%, which would ensure that we don't lose revenue. Madam Speaker, this is just a few points I wanted to just highlight. But again, as I said, I'm in full support and recognize that it would be an ongoing process to get this act to where we want it to be. Thank you, Madam Speaker.
Madam Speaker, I rise to support this bill, and I must commend the Honourable Prime Minister for this very impressive executive summary of the proposed act. And also it speaks volume, Madam Speaker, of the hard work that has gone in thus far in getting us to this point. And I think also it's refreshing to have heard from the members on the other side giving their full support, not partial, to this very progressive proposed act. The member for Marigot, the leader of the opposition, interestingly and ironically referenced Section 97(2)(a), which places the qualification requirement on officers and directors, etc., as per the proposed measure before this Honourable House. That notwithstanding, Madam Speaker, he also made reference to that the act in itself, or the proposed act, will change the manner in which banking transaction is done in the international banking community. But I wanted us to differ with him slightly and to say, and to spin it around, and to say what obtains in the international banking community obligate us to enact such a measure. Because we cannot withstand another 2008 financial crisis. What we are proposing to do here by virtue of this act or this bill is precisely what already obtained internationally. And our failure to act will present tremendous challenges to our domestic banks. And already, Madam Speaker, our local banks are having tremendous difficulties and challenges because the ability for a number of our banks to transact internationally is predicated, Madam Speaker, on their relationship with correspondent banks in the US, in France, in England. So if we do not meet certain best practices insofar as banking is concerned, a number of our local banks, Madam Speaker, may just face what we call blackouts. And I believe, therefore, that some of the persons, or the members, sorry, who presented thus far reference that, Madam Speaker. And I want to say further that in a number of communities or countries within OECS catchment, we have seen the passage of a similar legislation in St. Lucia, I believe also in St. Vincent, and the bill has gone through the first or second reading in Antigua and Barbados Parliament. So Dominica is not the first country seeking to take this measure. And then we, not by option, but by choice, we have an obligation, therefore, to pass this measure. Now, the member for Roseau made some very salient points, and that in itself, and also Senator Fontaine. And just to refer to what Mr. Fountain said just now. No, the pith and substance of any act most time can only be appreciated when that act is actually implemented and applied. And then after the application, and you see the manner in which it is applied, you may come back to Parliament and make the requisite amendments. So I want to concur with you that insofar as, because of course no bill or act is perfect, and I'll be the first to admit that. But I believe that some of the comments that you made carry some merit, and that has to be recognized. Going back to Senator, the member for Roseau, sorry to call the senator, and who made a very important intervention in that regard insofar as it relates to protecting the interests of the depositors. And that is precisely, in the main, what that bill is intending to do. Now, there's also the need to place greater responsibility on the inspectors to ensure that you have compliance to best practices insofar as banking is concerned. And the intention of that bill, therefore, is to do just that. Now, we know what the experiences have been in the past. When you have directors of banks and financial institutions may give direction to make out loans to friends and companies in which they have interests. And that cannot be tolerated. That cannot be right. So we have to therefore act in mitigation against those actions. And that is precisely what that bill is intending to do. Now, much was not spoken about in that regard. We have been talking for a long time about an economic union within the OECS catchment. But the number of prerequisites that must be in place before that eventuality can be realized. And I believe that in that regard, that bill can be seen as a very progressive move towards attaining that economic union we have been speaking about. And why do I say that? Now, the leader of the opposition, quite rightly so, made reference to the creation of a single banking space. But when a license would have been issued to a bank within any member state, that bank will have the authority, Mr. Speaker, to operate in the entire currency union. And I believe, Mr. Speaker, that has to be underscored. So already, this bill is contemplating, to an extent, in the economic union within the OECS catchment. And I think I wanted to say that. So, Mr. Speaker, insofar as ensuring that persons who have worked hard and have placed their monies in bank, etc., the member for Roseau made reference to mortgages, etc., and contractual obligations between the banks and persons who would take off mortgages, etc., etc., and persons who invest. There's a need to ensure that there's some kind of monetary requirement. That's the reason why you're seeing an increase insofar as the threshold is concerned. And most of the speakers on the other side made reference to that. The leader of the opposition made reference to $20 million threshold for the banks and $5 million threshold for credit unions, etc., and other lesser financial institutions. But that is significant. Had we ensured that before, a number of persons who are putting in their life savings and investment would have been protected. And Senator Fontaine made reference to the exposure of government, and some government, of course, take huge loans. But what he did not say is that by virtue of the fact that there are so many persons within member state who had the investment, their life savings, in a number of these financial institutions, and when they went under, as a consequence, that created tremendous exposures to member state. Because there are a number of persons in Dominica, those of whom I know, who had their life savings, and it's totally vanished. Then that places a moral obligation on member state wanting to come around to mobilize the requisite resources, financial resources, to save the people's investment. You get my point? So I believe that as an economist, of course, you have the expertise. You have to ensure that you do not look at a situation from a one-dimensional standpoint, but also give a total outlook of the situation. I just thought I wanted to say that. So, Mr. Speaker, I support this measure. I believe it is a very progressive one, and we cannot wait. I know the leader of the opposition like to reference a great quote of Martin Luther King. How long? Not long. I want to say, not long, but now. Mr. Speaker, I want to recognize the Financial Secretary, a great Dominican, who I know has been working very hard also in ensuring that the requisite technical support is provided to the Minister for Finance. And also say in closing, Mr. Speaker, I'm not surprised because she's from the Mao constituency, a place where my father was born, Massac. Mr. Speaker, I support this measure before this honor of the House.
Mr. Speaker, I rise to support this banking bill on the basis that it's extremely important. And I don't think we should wait on the basis that many persons' hard-earned income is in the hands of the banks. And based on the emphasis placed on proper governance and accountability, I think it'll force all those who are responsible to ensure that the depositors' funds are secured, starting with the shareholders, who are the ones who have invested in these institutions, who will set, I guess, a very broad framework in terms of what they expect, most probably in terms of profitability. The shareholders then put a board of directors in place, who are the ones who truly control the bank to a certain extent. And obviously, as you can see, that the board will now be held more liable for these decisions that are being made. It also goes down to the management team, because the management team are the ones who execute the direction of the directors. And these three levels at the top are the true ones who can make or break the bank. And as I said before, I truly feel that we cannot wait and we should not wait. We should put these things in place. Based on my previous experience I have gone through some of this with regards to the insurance business, and obviously the most important person is the policyholder, and in the Banking Act it is the depositor. And as one of the other members also mentioned, even some of the consumers who may not necessarily have loans or who may not necessarily have deposits, but who does actually business, you also have to ensure that the fees that the banks charge are properly controlled so that the consumers are not being taken unfair advantage of. In terms of the capital requirement, it is a significant increase to $20 million, but it also goes a bit further. It also talks about a reserve. So it is not only just the capital requirement, it also includes a reserve of 20% of the profits that will be kept in the country. And even the reserve, even the capital requirement has to be unimpaired, and it must be, where is it? It must be maintained in Dominica. And the reason for that is that in the event that the bank goes belly up, the regulator will have access to those funds. So the funds where we're talking about, based on here in Section 44, has to remain in Dominica. I also agree that there should be an insurance fund, not an insurance fund, but insurance for the deposits. But I'm sure, based on the importance that the Act can go through now, and in the near future, when you get all the other feedback from the stakeholders, that some of these shortfalls can be put in place. Some mention was made of the other institutions which may be unfairly taken advantage of based on the high limits. But these other organizations that some members talked about, there is regulation, specific regulation that covers them, so that would not be an issue, and there aren't even any capital requirements for that. The major part of it is really more the consumer protection to ensure that persons are not charged unnecessarily high interest rates for the risk involved. I also agree in terms of the persons who default, the extremely high interest rates that may be compounded on them. There has to be legislation to ensure that that is put in place. But again, that can be done in the second phase. In terms of the protection of the homeowners, I don't think any change has been made to that section of the Act. And I feel that the homeowners are truly protected. The banks it's never easy for the banks to just sell someone's property. So the homeowners are truly protected. I guess the only issue is truly the interest rates that are being put on them. There is some concern that you want to ensure that banks are not unnecessarily thrown out of the market, because we all know that the local banks tend to be a little more receptive to the local entrepreneurs. So there has to be a fine balance with that. But at the same time, you still have to, in terms of the balance, you cannot be too lax and that it comes back and it affects you. So there's these few words. I totally support this new Banking Act, and I think it should be passed immediately. And based on the feedback from all the stakeholders, the necessary changes can be made. I thank you.
Madam Speaker, I too wish to lend my support to this bill. The Banking Act 2015, as it is before us, as has been said by the previous speaker, it is a bill of some length, but it's also a bill which is very important for our financial sector. In a small jurisdiction such as Dominica, the integrity of our financial system is of paramount importance. We have heard mention of corresponding banking, and we've heard mention of the challenges that as a country we can face should we find ourselves in difficulty with our corresponding banking arrangements. And indeed, we will recall that we have had difficulties in the past, and we know how challenging it can be for the individual as well as for businesses to be able to transact business if we lose or have significantly restricted our corresponding banking arrangements. Madam Speaker, I don't intend to say very much. The Minister for Finance and Prime Minister, in his opening presentation, set out in detail the substantive elements of the Act, and we all were able to hear and follow it. We've also heard a number of observations made about various concerns regarding the bill. The unfortunate thing is that those that were made today are being made at a very late stage. Perhaps of some comfort to the members who raised them is that a number of them have been raised during the stakeholder discussions that were referred to by the Honourable Prime Minister, Minister for Finance, when he addressed the House earlier. So some of them have, in my respectful view, perhaps more substance or more merit, maybe I should say, than others. But as has been indicated, those that have previously been raised have been communicated to the ECCB authorities and are being reviewed and considered. Those that have not, and I can't say that I identify any specific ones that haven't at the moment, but certainly I've noted a number of them myself, and I'm sure that they also will be communicated. But the reality, Madam Speaker, is that we need to proceed with the bill. It is a working bill, and if it is passed and subsequently enacted, it is in a form that will enable our financial system to work and work effectively. Whilst, of course, any of the concerns that are raised will continue to be raised, as will no doubt other concerns, because as with any bill, any act that's passed, it is only when the act is rolled out and it's in operation that one gets to see some of the things that perhaps one hadn't necessarily thought about. And even with some of the concerns that have been raised today and previously, the reality is that whilst they appear at first blush, as one may say, prima facie, to be concerns of substance, some of them are in fact, if one were to take the action that's been suggested, the likelihood is that one would end up with the existence of the law of unintended consequences. That is to say, Madam Speaker, that one sees or perceives a problem and thinks that one can address it. And in attempting to address that problem, one actually creates other problems that one had not foreseen. So I'm not saying that, Madam Speaker, to diminish the observations that are made. In my view, certainly the vast majority of them are observations that, on the face of them, are worthy of consideration. I'm simply saying that some of them have already been given consideration. Some of them could perhaps be revisited, and it may be that there will be a need for amendment in relation to them, or indeed it may be that a more fulsome response will be given that may allay the concerns of those who have expressed them. But all in all, Madam Speaker, my understanding is that the bill as couched and as intended, provides a regime for banking businesses and is not intended to, nor does it address credit unions. My understanding is that credit unions have a particular type of arrangement, and indeed, if you will, credit unions are actually clients of the bank, as I understand it. I am not an expert in that area, but my understanding is that credit unions have to bank with one or other of the institutions or multi-banking institutions as they are, so that the existence and operation of the credit unions, as against what is termed as the banking business, which is the normal banks that we have, is different. And so my understanding is that the credit unions, as other cooperatives, are regulated by that particular regime. So it may be, Madam Speaker, that further consideration will need to be given to arrangements or additional arrangements to regulate our credit unions, particularly as we note that credit unions in Dominica, at least, are growing by amalgamation and otherwise, and the potential impact on our financial institutions and our financial system, if there were to be some significant difficulty with credit unions, could have an impact that we would not require. So that's a matter, Madam Speaker, that I'm aware that the authorities are aware of, and no doubt in due course, if it's necessary, will be addressed. So, Madam Speaker, I think really that what I should say to this House is that this bill is a bill which this House should endorse by passing it today. The 193 sections and the 4 schedules cover a wide gamut of issues, and really, as has been indicated by the Honourable Prime Minister and Minister for Finance, referring to the specific chapters or the heads of the chapters, covers everything that we could realistically expect a banking act to cover. Madam Speaker, with those few words, I commend the bill.
Madam Speaker, I rise to conclude the debate on the Banking Bill 2015, which is before us in this Parliament. We've noted the comments that have been raised. Some of them have some merit, some of them, in my respectful view, do not. But it's interesting to know, Madam Speaker, that, as I indicated, we sought to ensure that all of the major stakeholders would have had a say in the process by having the bill sent to them, and they send comments in writing in some cases, and others invited to have a face-to-face exchange, especially the banks, especially the representatives of the employees, and also the employers, Madam Speaker. All of those stakeholders, the private sector that does most, if not all of its transactions with the financial institutions. Because we recognize that there are issues to have been discussed, and allow that discussion to take place. And as I indicated also, Madam Speaker, as part of the consultative process, we did in fact write to the Leader of Opposition sometime in April. And a copy of the draft bill was sent to him in April. I believe maybe the middle of April thereabout, or early April, middle April, which is long before the convening of Parliament. As a matter of fact, we had not set a date for the convening of Parliament when that was sent. I would have expected that it would have been read then and possibly shared with the other colleagues to review, and comments would have been sent to us in writing or otherwise, so that we could have had an even more wholesome discussion and debate on this important piece of legislation. So it is unfortunate, but be that as it may, we are here in the Parliament today discussing this legislation. And I did in fact indicate the rationale, the reasoning, the justification for this legislation. Now, no legislation is perfect. There's no legislation on our books is perfect. And at the same token, one cannot put everything in legislation. There'll be regulations that you will have to draft and develop to strengthen and to give further details as to the operationalization of the various sections in the legislation. And those regulations would be prepared and would be provided so that it can bring greater clarity and finality to the issues that we're seeking to address in this legislation. In respect to the credit unions, Madam Speaker, we recognize the important and critical role which credit unions play, especially in our case with regards to the NCCU, Madam Speaker. The NCCU is a major institution, and therefore, if anything were to go wrong with it, it will have an impact on the financial system. Credit union business, the way they call it credit union transact business today is not how it was in 1955 or 1960. The landscape has changed, and therefore, we have to ensure that we also take that into consideration. So regulation is important. Oversight is important. And I heard people talk about giving the central bank all this authority. The central bank is a creature of our parliaments. It is that institution that deals with the monetary policies of our currency union. So if we say that they have too much powers, then who should we give the powers to? And ultimately, as ministers of finance, we have responsibility for the entire system as governors and councillors in the Monetary Council. So while we are delegating the authority to grant a license to the central bank, we're not delegating our constitutional authority as ministers of finance, because we still are members of the currency union, the council. We attend meetings, we set the policies, we set the framework. So that decision was taken by the ministers of finance collectively, recognizing that we have to take action as strong as they appear to be, and they're in fact strong measures. Looking at the present landscape, the present operations, and how things are happening, and what can you do to fix them, to ensure that they don't happen tomorrow. So, Madam Speaker, this is work in progress. Now, 5 years down the road, 2 years down the road, some things may come up. And that's the point I made earlier, member for Roseau, that we are highly exposed. That's what we call open economies. And the things we have control over, we must take charge of them. So when the external shocks come, we're in a position to withstand them as far as practically possible. And that's what we say that with this legislation. So we have to appreciate the situation. And this is why in Europe, in the United States, new regulations were imposed to ensure that directors and shareholders and employees are more accountable and take greater responsibility for what happens in the banks. Because when people put their money in, they put the money with you in trust. It is not your money, it's their money. And therefore, if somebody puts their money in your trust, they expect that when they come for it, that it is there to be given to them. And we have to ensure that when loans are being given, that they have this requisite coverage, the securities that are required. Because the bank is taking the depositor's money to give somebody else a loan. So it's not the bank's money, it's people's money. And therefore, we have to ensure that everybody who works in the system, and I understand there'll be reservations, there'll be concerns, there'll be apprehensions, Madam Speaker. But I believe if we all conduct the business properly, then there should be no real issue. And what this legislation is seeking to do is to place this in a framework, put everybody within a framework so they know within the boundaries and the perimeter within which they'll be operating. So that we don't have ourselves not understanding this and going beyond that and creating problems, Madam Speaker. So while we may not have, as I said, Madam Speaker, those issues here in Dominica, but we have a responsibility to the greater good of the monetary union. And on the issue of our money will go to another country and all people will benefit it, I mean, that's an archaic view of how things are in the world. This is a global village. This is a global village. That you'll have Dominicans who will want to go outside Dominica to do business, but who may not be able to use their assets in Dominica in St. Vincent to contract a loan from the bank in St. Vincent. But with the creation of this thing, because we have a single economic space, the intention is to ensure that you can use your assets there, because one of the things that we're dealing with is asset registry. So you have business in Dominica, you have property in Dominica, you can use that in Grenada to get a loan in the banks in Grenada. That's where we're seeking to get things going. So the idea of trying to bring in the minds of Dominicans this unfair, uncalled for fear is a dangerous thing to do as leaders. To give Dominicans the impression, Madam Speaker, in a very subtle and smooth way, that this legislation is making provisions in some way or fashion to take their monies from Dominica, hard-earned money from Dominica, and send it elsewhere, where they would not have benefit to it because other people will have benefit of it and not them, is not a wise thing to do if we come in here in a pious manner saying that this is not politics, this is about national development. We must get together as parliamentarians and let's discuss things and so forth. Let us come with clean hands. Let us not come with motives behind those utterances, Madam Speaker. Let us be genuine about those engagements. And this is why we have taken a new approach to bringing legislation to Parliament. And this is why I insisted that the bill be sent to the Leader of Opposition, because I understand the extent to which the bill is going. We won't send every piece of legislation because there are some things that are mundane. I can see the sadness in your face, Member for Roseau Central, and the disappointment in your face, Member for Roseau South, that wasn't shared with you. And this is why you said here in your contribution, look, Madam Speaker, look. I am unequivocal in my support to this bill, and what I'm going to say is not contaminated by anything that has been said before in this House. You see what I'm saying? So I appreciate those kind of genuine comments, Madam Speaker. And if there are issues that we have to look at in the Parliament, whether in committee stage, then that's fine with me. And then also conjectures are coming in about My Dominica Trade House and about holding companies. You know,
to allow them, so I don't even want you to mention.
I'm not going to talk about, Madam Speaker. I'm making reference to that. You see what I'm saying? And so that's the kind of approach you want to take. Well, you can take an approach. Well, we can deal with those things here. Of course we can deal with those things here. You can say what you want on Q95, but no, when you come here in the Parliament and you say something, we can respond to you. You don't have control over the console. So let's understand it. Let's understand it. But come with your facts. Come with your facts. So when you come and talk about My Dominica Trade House, then you must also come and talk about e-promo.
No, we're not going there. We're not going there, please.
I'm not going there. I'm not going there.
Let's just close up now.
Madam Speaker.
Want him to go there?
I'm not going there, Madam Speaker. Madam Speaker, e-promo is an account in a bank in Switzerland.
I don't want to
know.
know.
Tell you a bank. Joshi, Security, I know you. Ask about e-promo. So, Madam Speaker, the point is, you know, it's work in progress. This bill is not the end of the issues to be addressed. It's work in progress. There will be further discussions at the Monetary Council because issues have been raised as we go along the consultative process. I have deposited all of the points raised by the stakeholders with the central bank, with no exception. And I have said there, Madam Speaker, some of the concerns raised by some of the stakeholders are legitimate concerns. But at the end of the day, one must understand that if there is collective responsibility, I cannot break away, or Antigua cannot break away because of small people maybe raise some issues. This collective responsibility, we have a collective responsibility to protect this single financial space. So to ask me to depart or break away from a decision taken by the Monetary Council, of which I am a member, representing the Commonwealth of Dominica, is not a good governance practice suggestion. This has been devious, this has been deceitful, and so forth. So when you come here and talk about good governance practices and qualifications to hold office and so on, examine ourselves. Examine ourselves, Madam Speaker. I said yesterday, Madam Speaker, you see, I do not want to respond to salacious comments on all these things. But I also said that if those things are raised in the Parliament, we will respond. Never believe that we have no information. Never believe so. You can run him up on a radio program, but never believe that we don't have information. So I see minds spinning when I mention e-promo. I can say to the people of Dominica that this government has no holding company anywhere in the world, Madam Speaker. Nowhere in the world. But I leave the e-promo question out at a later date, not in these proceedings, but in other proceedings we shall discuss when the time allows, Madam Speaker. I want to thank you, Madam Speaker, I want to thank the members, and to say that there are challenges in the world, and we have to try to be equal to those challenges. Or else, when we're trying to protect this or protect that, we very well find we're left with nothing if we do not take action. Proactive, preemptive action. And in some cases, corrective action, Madam Speaker. So, while all of us will have concerns, let us look at the greater good, the greater importance of this. And the question is, Madam Speaker, if not this legislation, then what? It's always good to say, well, this shouldn't be done, that should be done, but what it is. So when I heard some members reading from the bill, but not giving any concrete counter view. So we read the bill, the leader of the opposition has read the entire sections, at least those I did not read, he read them. But he only read. There was no concrete alternatives put forward. So he reads well, so he's some bright reading this thing, but he has not presented any counter proposals. As you say, well, I don't agree with this, so I'm proposing. And this is what we expect if you had the bill from the 20th of April to do. To call me. Right back to say, well, I have read the bill and these are my concerns. Remember, Roseau, next time I will send a copy directly to you. I will send a copy to Mr. Linton, and I will send one to you, so that the leader of the opposition, and I will send one to you, Mr. Member for Roseau, so you can share with the member for Roseau Central, and share with Senator Thompson Fountain as part of your the side of things. Thank you, Madam Speaker. Thank you, Madam Speaker. No, we have, Madam Speaker, if the high incidence of CNCDs, we have to eat on time. Yeah, so, Joe.
Reading. It has been moved and seconded that the bill shortly entitled the Banking Act of 2015 be read a second time. Those in favor? Aye. Those against? The ayes have it. The bill will now be read a second time.
Banking Act 2015.
Okay, we'll do the committee stage when we come back, or do it now. Finish. Finish it.
Madam Speaker, you haven't admonished me. My colleagues have said that we should go ahead and finish it.
Okay. Good. Okay, the bill will now be committed to a committee of the whole House to be considered clause by clause. Yeah, let's get it over, man. House resumes, and I have to report that the bill shortly entitled the Banking Act of 2015 passed the committee stage with a few amendments. The question is that the report of the committee on the bill be adopted. Those in favor? Aye. Those against? The ayes have it.
Madam Speaker, I move that the bill shortly entitled Banking Act 2015 be read a third time and passed.
I beg to second, Madam Speaker.
It has been moved and seconded that the bill shortly entitled the Banking Act of 2015 be read a third time and passed. Those in favor? Aye. Those against? The ayes have it. The bill will now be read a third time.
Banking Act 2015.
The bill has been read a third time and passed accordingly.
Thank you, Madam Speaker. Madam Speaker, I move that the House be adjourned sine die.
Madam Speaker, I beg to second.
It has been moved and seconded that this honorable House be adjourned sine die. Who is in? How? Those in favor? Aye. Those against? The ayes have it. This honorable House stands adjourned sine die.
Madam Speaker.